This beach nourishment, is it the static line, the line that's supposed to be used?
The statute requires that both lines be known and shown. And the beach nourishment should not have any impact on this. You're not allowed to build, beach nourishment system under the law doesn't, you're not allowed to go and, because you got beach nourishment, you've got a larger lot, now you can larger stuff, you're not allowed to do that under the law.
We're looking for motions right now, so. And
So-
you've said that you thought this was, I think what you said was there was nothing to go on. So either you're making a motion that you want to continue with the hearing, or you'd like,
Actually, what's occurred is, Mr. Hornick made a motion.
I didn't realize that, but you're implying that you
And
have
I'm
nothing
responding to his
to.
motion, and I'm going, this doesn't make sense
Well, what does that
for
mean?
us to be spending this body's time arguing over something that there's nothing we can do to contest what's occurred with this new piece of information that has come into the picture.
So you're implying,
No, I mean,
so you're implying that we should dismiss it because you have no reason to believe that its dismissal is unreasonable.
it's clear to me that we can't prevail in our case here.
Okay,
That's
well,
what it's clear to me.
okay.
Are you done, Mr. Short?
I'm done answering, yes.
Yeah,
I'm done.
great, thank you. Mr. Hornick, or Mr. Hobbs first, do you have any addition or response?
We do not.
Okay, Mr. Hornick.
So, I apologize, I think that kind of this odd tangent we kind of went on is a little bit of my responsibility. What I'd like to do, Mr. Chair, if it's okay with you and the rest of the board, is kind of explain the legal arguments for our two motions to dismiss to you. That will hopefully, I think, answer some of the questions or issues that have been raised. Would that be all right? Primarily should have been certified one way or the other. So in my mind and in my client's opinion, this entire proceeding is moot because it really makes no difference which line is used to measure. The lots still exceed that minimum lot area requirement. So that's our motion to dismiss for mootness. Our second motion, our motion to dismiss for lack of standing, is based on the fact that the exhibit to the appeal, the application for appeal, which Mr. Barnell submitted, makes a conclusory statement that the appellant has standing based on North Carolina General Statutes, Chapter 160D, 1402C, 1B, I believe, which is that he'll suffer special damages as a result of the decision being appealed. They made no factual allegations in the appeal letter to support that. North Carolina law requires that in order to have standing, an appellant must submit credible allegations to demonstrate that they will suffer special damages as a result of the decision being appealed. Now, first, the appeal application doesn't include any factual allegations at all, credible or otherwise. It includes simply a conclusory legal statement that they meet a standard outlined under state law. But even more to the point, we don't believe that they could make credible factual allegations of special damages anyway. Under North Carolina law, well-established law, in order to suffer special damages, a property owner would have to show a number of factors. So the first being that the decision being appealed would cause them, or that they own the property in close proximity to the property that is the subject of the decision being appealed. Second, they might show that the decision being appealed would have an adverse impact on their own property value. And then third, they'd have to show that there are any number of additional adverse impacts that they would suffer. So additional stormwater runoff, additional traffic impacts, noise, light pollution, that sort of thing. They've not done any of those here, nor could they, because the simple decision to certify an exempt plat does not authorize any new or different use of either of the lots. It doesn't authorize construction on the new lot, Lot B. So there's nothing changing about the condition or use of these properties that could create any impact beyond what currently exists on the ground right now to the neighboring and nearby property owners. Moreover, state law says that those special damages have to be suffered by the appellant, him or herself, and distinct from the rest of the neighborhood. So even if the appellant were to say, credibly, that they might suffer from increased traffic because of the potential speculative future development of this new lot with a use that is compliant with town code, that same harm would be suffered by every property owner or resident along Ocean Bay Boulevard. It would not be distinct to Mr. Block himself. So really, under no set of facts could the appellant even make those kind of credible allegations of special damages that they would need to. And the plain fact is that they have not made any of those credible allegations, at least so far. So that is our argument for our motion to dismiss for lack of standing.
Before we go any farther, can I ask if I can get like a point of law? It sounded like, and I want to make sure I understood both parties, because it seems like we got a contradictory statement. Mr. Sharps said that he expected the first line of stable natural vegetation to be behind the static line. And if that was the case, then the lesser of the two would apply. Is that right, Starkey? Now, and you're implying that the greater of the two. Now, which one is it? Do we have an actual copy of the law? So they both can't be right. It's either the lesser or the greater.
I believe, and I'll try to pull it up as well, I believe that's what Ms. Cross is doing, but a copy of the definition of lot area is included in the appeal application. I believe it's on the second page of Mr. Varnell's letter. And it defines, you all should be able to read it, but I can read it into the record for you as well. It says, lot area is the total horizontal area included within the lot lines, For the purposes of determining lot coverage, maximum building size, or number of bedrooms, the lot area for oceanfront properties shall be considered the area landward of the static vegetation line or first line of stable natural vegetation as determined pursuant to CAMA regulations that lie within the remaining lot lines, or the lot square footage determined by the Dare County Tax Assessment Office for real estate tax assessment purposes, whichever is greater. So it's clear that the town code's definition requires whichever of those three methods of calculating lot area that results in a greater lot area to be applied. Now, it might be true that under CAMA regulations, in certain circumstances, when you're dealing with development setbacks within ocean hazard areas, you would apply whichever of those two lines, the static vegetation line or the first line of stable natural vegetation, is more restrictive. But that's not what we're doing here. We're determining whether or not an exempt plat met the requirements under state law to be certified by the local town staff.
Well, and
I think the difference here is this isn't a CAMA question. This is a subdivision question based on whether or not the lots, the resulting lots of the subdivision meet the standards of the town code. So you're going to look at the town code's language to determine whether or not it meets those standards.
And I'll add as well, and I have copies, I believe, for all of you, but this, I think the board can take judicial notice of this. The CAMA regulations definition of development does not include subdivisions or other divisions of land. So, to the extent that the appellant's argument, to the extent that the board found the appellant's argument credible that somehow the CAMA regulations should trump the town code and state law with respect to exempt plats, the type of land decision that's at issue here wouldn't even be included within the scope of CAMA. CAMA is related solely to development in certain ocean areas, and the subdivision of land is not included within that definition of development. So it wouldn't apply anyway to this. Construction on these lots would certainly, or may anyway, be subject to CAMA regulations. I would leave that up to Ms. Cross, but the simple division of this parcel of land into two lots is separate entirely from CAMA's regulation.
Mr. Go ahead. I was going to ask Mr. Hobbs if he had any response to Mr. Hornick's recent arguments.
No, town staff agrees with those as far as the reading of the lot area definition and the fact that it is the greater of the three clauses that are listed. You just went through.
Thank you. And are you done with your argument?
I'm done with my arguments.
Okay, thank you. And Mr. Sharp, do you have any additional response?
On the special damage issue, that's what this hearing is about, or would have been about, before this development that I explained earlier. Mr. Blaha is prepared to explain how building an additional house oceanfront, since he's the next adjoining owner, is going to impact his value, impacts including traffic, noise, light, property values of his home, a number of other things, and that's what we were prepared to present evidence on and are still prepared to present evidence on. We don't have to put all of our evidence in the application for the appeal, and I think we've sufficiently identified it. On the standing issue, I think that the way I read that definition that they just discussed was, consider the area landward of the static vegetation line or first line of stable vegetation, parentheses, as determined pursuant to coastal area management regulations, CAMA regulations, that lies within the remaining lot lines. And you take, that or is a limiter between those two. And or the square footage determined by the Dare County Tax Assessment Office. But what's occurring is the town staff, or we move forward, but when they granted the approval, determined it using the information lacking the first line of stable natural vegetation. So they didn't follow your ordinance. They didn't include the stable vegetation line, the first line of stable vegetation, in making their determination. And so it should have been included at the time. And what appears to our eyes is that it was determined after we've spent this time in the appeal. That's what's occurred here. After this appeal has gone on, and after we've gone and spent lots of money with expert witnesses and lawyers preparing for where we are to add this in, and pull the legs out from under the appeal. That's what's so offensive here. That's what's occurring. And so that was the legal basis, okay? You didn't determine the first line of stable vegetation. It's in there, and your ordinance requires that you have it, and you didn't. And so I think I've made that point earlier.
Mr. Sharp, can I ask you a couple of questions? You agree with my prior statements that the board can either reverse, affirm, wholly or partly, or modify the decision appealed from?
Yeah.
Okay. And do you agree that they can also make any order, requirement, decision, or determination that ought to be made related to that?
Yeah.
Okay. And do you agree that they have the powers of the official, Ms. Cross, who made the decision?
Yes.
So am I correct in hearing that you don't have any evidence contrary to the just let me finish, to the plat that Mr. Hornick intends to produce that would show anything any different?
The only people who can do it is CAMA, and the only people who can contest it is the state.
Okay, so the
evidence we wanted to present is evidence about damages, about his special damages, about his Mr. and Mrs. Blaha together, their position where they have the right to have brought this forward to the town and to make the appeal, which I think is quite clear that they do. And we wanted to get that evidence in place and so forth. But this was not a frivolous appeal. It was our position that the first stable line of vegetation was landward, and that this lot would not have had the square footage. That's where we were heading for where this was going on, and that should have been determined by the town staff at the beginning of this. And that's what the objection was raised.
But you agree that currently the evidence is going to put the board in a position where they can't make a determination other than to affirm?
Correct.
Okay. So going forward with the hearing,
it spends everybody's time.
Is a foregone conclusion of what the result would be.
This is correct.
Okay.
And I think that, that's why I got up and said what I said. I didn't put it in the form of a motion. I put it in the form of explaining to you what's going on. And now Mr. Hornick has come in with his motion for standing and his motion to dismiss for on the special damages issues, okay, which, given what I just told you, was a surprise to me. This was not a frivolous appeal. I think Mr. Blaha had the basis to do what they're doing. I think it was appropriate to do so, to come forward with their appeal in the position they're in. So.
But you would agree that mootness can arise,
yes,
can arise later on in the,
yeah.
And it probably has arisen here? Okay.
Right.
Thank you. Mr. Hobbs.
Mr. Sharp, I have a question. With regard to the standing issue, you had said earlier you were going to place your clients on to give testimony dealing with, I think you said, property values, effect on property values. Section 160D-1402, J3 talks about competent evidence before a quasi-judicial hearing, and it specifically states that evidence dealing with property values and increased traffic can only be made by, cannot be made by opinion testimony of lay witnesses. So do you have any expert witnesses to give that type of testimony to deal with standing and special damages.
The standing motion is a surprise to me today to come in here. We lined up witnesses, and Casey had witnesses in place. They are not present today. We did not bring in George Wood, who was going to be our CAMA expert witness, to provide testimony about which of those lines is relevant and the impact it has, because it doesn't make sense to bring him in, as Mr. Gallup has just explained, for what we can see as a foregone conclusion based on what's happened with this. We also did not bring any other witnesses here. The only people I have here today are Mr. and Ms. Blaha. It would be useless for us to have brought the people that are necessary, like an appraiser and other witnesses. We were prepared to bring the witnesses we needed for this hearing for matters that were properly before us that Casey had in hand. But no, they're not here today. I didn't bring that, and I'm not going to waste the board's time on that.
Thank you, Mr. Sharp. Either of the other, Mr. Hobbs or Mr. Hornick, anything else? Okay. Mr. Chair, it's before the board now to determine ruling on Mr. Hornick's motions to dismiss. He's got two motions before you. One is a motion to dismiss for lack of standing due to mootness, which essentially, as I just discussed with Mr. Sharp, mootness is when something becomes a foregone conclusion. That's when mootness arises. That there's nothing that can be done as a result that will give them the remedy that they were seeking. On the question of special damages and standing, I, in past, have agreed with Mr. Hobbs that you had to have expert witnesses for that, but I learned last week at a hearing that there are cases that say that for the question of special damages, you do not have to have that. But you do have to put on special damages evidence, and we don't have any of that has been put on or offered prior to the decision on this motion. And sometimes that can be put in via affidavit. Sometimes you have a particular hearing just on the special damages question because it's at issue, which is what we're dealing with now. My analysis, which you absolutely can disregard completely and determine that I have no idea what I'm doing, is that you should probably grant the motion to dismiss for mootness. And that lacking any evidence being put on of special damages, that the law would ultimately, a court would likely uphold the decision for a dismissal on that ground as well.
I'm only used to Robert's rules in a club situation. Does that motion need a second?
No, that's a motion more like a court. So
Okay.
It's like it's a motion to dismiss. So y'all act as a judge, a 1, 2, 3, 4, 5-headed judge with a lawyer who kind of sits next to it with the alleged legal mind of the judge. And so they're acting like y'all are a court in that regard. But then as a body, one of you would need to make a motion to either grant or deny their motion to dismiss. Sadly, the term motion is used for both, but they're completely different things.
Thank you.
Yes, ma'am.
I will ask for a motion in just a second. But, the only thing that I guess is I just want to make sure is that still the position of method being used. One party is stating that it's the greater of three methods: county, tax assessor, also cameras, and the static line. I mean the current line and the static line. Current line is what we just recently received this weekend. At least that's an official line by CAMA. The static line we've had the whole time, and we've also had from a third party the county tax assessor's assessment, which was less than ours. So whether we got this before this weekend or after, if it's true that the lesser of the three, then in all fairness to both parties, there's a different situation versus greater of the three. And I think it's clear that it is the greater of the three, at least, I mean, I'm still, Sergeant, when he presented all three the second time, he didn't say lesser or greater. He just said they could use any one of three methods.
I think I can explain what the difference is. Mr. Hobbs and Mr. Hornick read the clause as having three different measurements, the greater of the three. Mr. Sharp is reading the clause as having two possible measurements related to the static/vegetation line that you take the lesser of under CAMA regulations, and then there's two, the lesser of those two applies to the greater of that number and the county number. So it's an analysis of the English, but I think the ultimate result on the mootness question says it doesn't matter because all of the lines are greater.
Plus, we're here for county, or not a CAMA jurisdiction.
Well, even if it was CAMA, the lesser of the two between the first stable line of natural vegetation and the static line, both of those lines meet the numbers. So even if you took the lesser, then that's where the foregone conclusion concept of the mootness comes in, that it doesn't really matter whether it's the lesser of those two lines under the CAMA analysis or the greater of those three lines. They're still actually greater, and they don't have any evidence to the contrary. So,
Well, the way I understand it, for CAMA, the county tax assessor's assessment of the size has nothing to do with anything.
yes, that would even be in line with what Mr. Sharp was saying. So I think there's a parenthetical. I can't find it right here quickly in my notes, but I think there's a parenthetical in the sentence that lists the three things that says as found under the CAMA rules. So Mr. Sharp is reading that to say you got to look at the CAMA rules to determine between the first stable line of natural vegetation and the static line, and then whichever is lesser of those, then you apply the greater of that versus the county tax assessor line to answer the ordinance question. Whereas the town and Mr. Hornick are looking at it as there are three separate measurements that you determine those two CAMA-related lines based on how CAMA says where they are, but not which one's the right line to use. And then you look at the greater of all three. But the ultimate issue at hand on the mootness question is the fact that under the survey presented to which they have no response to, it doesn't matter how you do that analysis, you come up with the same answer, that it should be granted. So that's where the mootness comes in.
I'll ask, just make sure everybody's clear, and so we'll walk out. Do you want to make a motion to move forward with some evidence that you feel like supersedes anything that we've heard so far? And with a full-blown hearing. Full-blown hearing.
No, I don't want to make any other motion. I don't have another motion to make. I was here prepared to present our evidence for the hearing as I've explained. And we would have presented our value evidence and our testimony about special damages and our explanation of the rest of what's occurred. And the additional point I make, we can't go hire another surveyor. Put aside time, if we had time to do it. The determination of that line is made by the CAMA officer. The CAMA officer made the decision. The only body with a position to contest the determination of that first stable line, which is now has been shown to be eastward, seaward, is the state of North Carolina. And they're not coming into this argument today or anytime soon. So there's nothing we can do. That's where we are, all right? I just didn't expect it to be addressed in this context, but I understand what's happened. If you decide to handle it the way with this motion, that's fine. That's where that is.
Thank you very
Could I ask a question? I'm sorry, I'm a property owner, Motion Day. Can I just make a statement?
I'm gonna ask the town attorney. This is in
If they haven't made a motion to intervene and formally gone through the steps to show their own special damages and/or that they meet the standing, then the only part that the public plays in this is to provide evidence if it goes to a hearing on the merits.
My statement has nothing to do with property lines or anything like that. It's concerning myself as a property owner and the available parking spaces on these lots. It's about 3 spaces for a property owner.
Yeah, I would say it's really not a part of, it's not related to this hearing.
Correct. It's relevant to the town, and it's relevant to you, but for what we're here, and you have, attorneys representing both sides, it's not relevant to their arguments.
I understand. I'd just like for somebody to walk down there and take a look at the hazard they're going to have this summer when that house is full of people and you can't walk on the beach. We've experienced it all last summer.
All right, this
with
is
the
not
construction
appropriate.
crews.
And that's,
It's not only on yours.
you have recourse with the town, both the planning board and the town council.
Thank you.
Okay. Does anybody want to make a motion as to whether or not?
Oh, can you speak to the mic?
Would anybody on the board like to make a motion for dismissal or like to say something first?
I'd like to make a motion that, what would I call it to dismiss? We want to affirm what the council has already done, what the town has already done. So in terms of the motion, we want to,
I think if you're agreeing that it's moot and that they haven't shown the special damages, then what you would want to do is make a motion to grant Mr. Hornick's clients motions to dismiss for lack of standing, for mootness, and for lack of standing and mootness.
We have a motion, we have to either rule on that.
So one easy way to do that would probably be to say, so moved, if that's what you wanted to do.
that's what I was, so moved, I'd like to.
Do we have a second?
I would second that.
All in favor, say aye. Aye.
Okay.
All nay? The ayes have it.
And Mr. Finch, Chairman Finch, what I would recommend is that you direct Mr. Hornick to prepare the board's order for that, and that he circulate that to Mr. Sharp and/or Mr. Varnell, myself, and Mr. Hobbs, prior to Mr. Hobbs or myself providing it to you, either through Sandy or directly.
Okay. Not at this time. Okay, so I'd like to express appreciation to all the board members and the public. And I'm sorry if you didn't get a chance to testify, but maybe, like I said, you could, if you have feelings about this that you feel like should be incorporated in town policy, then you have both the planning board and the town council to address it with. So, if there's nothing else at this point, I'd like to call, Sandy.
I just want to thank the members that have, have any of you attended your training yet? So I've got a lot of good feedback from the planning board members. So make sure you're tuning in for that training. I think you'll get a lot of benefit out of it.
Thank you very much. Okay, meeting is adjourned.
Stand exempt now.
Good.